Hey everyone, Harry here to talk about the first hearing in the January 6th case before Judge Tanya Chutkan. Now, this hearing she called because the parties were feuding about the terms of a protective order. And they couldn't agree on it, and Trump was insisting that his First Amendment rights would be abridged if he wasn't able to take the materials he was going to get to prepare his case and use them as he wanted, including in the public sphere. And the Department of Justice said, wait a second, he's getting these materials to prepare his case. That's fine, but that doesn't give him license to use them. And we know how he'll use them. He'll use them selectively to try to give false impressions to the entire country, including the prospective jury pool in this case, and to intimidate potential witnesses. And their proof on that was pretty good because just in the last week, he's had several intemperate is too soft a word, just totally berserk messages about the case generally, about Biden, who he accuses with zero evidence. The evidence is all to the contrary, of bringing the whole prosecution. So all kinds of things on the pollute the jury pool side, and then also on witnesses. He comes after Mike Pence pretty viciously. And the Department of Justice has said, look, we're ready to give him, as we did in Mar-a-Lago, all these grand jury transcripts, which we don't have to give him normally until much later, but we'll do it now so we can really get on with a trial and quickly. We just need a protective order so he doesn't, abuse this information. All right, so that sets the stage. Today was the hearing, and I would say Chutkan gave both sides something. So first, in the most important and fundamental ways, she reaffirmed the government side. She came out of the box and said, "Look, this isn't you don't have regular First Amendment rights. You're a criminal defendant. You are released under certain conditions. Violate those conditions, then they don't apply anymore." And in particular, if you intimidate witnesses, if you pollute the jury pool, that's a reason to change the conditions of release. So she was pretty strong that way. And that was a message that DOJ would want to have delivered to Trump, who, by the way, was not in the courtroom. On the other hand, in the actual kind of arguments about what they should be subject to the protective order and what shouldn't be, Trump's team had said we shouldn't have non-sensitive material, and that's material that doesn't reveal grand jury stuff or pose threats. It's a little bit amorphous, and they may have to call balls and strikes on it, but they said that shouldn't be subject to the protective order. On that point, really the biggest point in contention between them, she agreed with Trump. She said, I'm not going to make these subject to the protective order. First, it is the United States' burden to show that they need to show really kind of concrete risks of potential for witness intimidation or polluting the jury pool. And she says they hadn't made the showing. That was a victory for Trump that was a little bit of a surprise, I'd say, because in many cases it's routine to just enter wholesale protective orders. Of course, it isn't the case in most cases, and anyone I can think of, in fact, that a defendant is saying, cleave off this little bit or however big it is of non-sensitive information. On the other hand, what she said was more or less what the department would have wanted, because she said, look, he's already subject to the requirements not to intimidate witnesses, not to pollute the jury pool. So if he does that, it's already a violation of the order. So I think on the one hand, she shows one, a sort of, listening hard to both sides, or at least wanting to have the appearance of being balanced, but also gives herself, I've said this before, what she basically needs is a fair bit of room between where they start and her final authority, which is what underlies her ability to keep Trump in line, and that is putting him in jail for civil contempt if he violates orders. So she wants that to be able to be gradual because he's a guy who's a serial violator, and she wants to say, now here's this order, now's that, now's a gag order. Next time, Mr. Trump, I'll have no choice. And at that point, if he literally, won't adhere to the rules of the court, we're looking at the former president in jail for a couple days where there's no hairspray and terrible food and the like. So, but she really, really doesn't want to move to that too quickly. So that was the resolution of the basic point. She said one more thing of real significance, I think. She said, I'm not going to consider the political campaigns and the timeline. I shouldn't, and I can't. So she's suggesting that the basic, she's suggesting a few things. One is if it comes to October, say, and it's in the shadow of the election and she has to set the trial, then she will. We'll see if that's the case. But also suggesting that to the extent the DOJ is kind of intimating, and they are in intimating, but not saying expressly, we really want to hurry up on this because he's trying to delay it past November, and the people have a entitlement to know what's the result of things. She basically, I think, says, I'm not going to think about that either. I'm going to pretend there is no political campaign. That, of course, becomes the elephant in the room. Can it really be ignored completely? But she at least drew the line in the sand and says, this is how I'm going to approach the case. All right. August 28th is the next and more important showdown when she sets a trial schedule. Then we'll really know the prospects for finishing this well in advance of November. The United States has argued we can do this starting the beginning of the year, January 2nd. And now on Monday, Trump's going to have to come out with a date. I don't think he can play it as he did in Mar-a-Lago and just say, we don't even want to set a date yet. I think he's, strategically going to be pushed. How far toward November can he go? And of course, if she's pretending is the wrong word, if she's putting blinders on about any of the political consequences, then in theory, all she thinks about is how quickly the case can come to trial. And the U.S. has set out a whole schedule that says we can do this in time by January 2nd. And I think, they wouldn't put that out if they couldn't do it. It would be a very ambitious schedule. I think everyone's anticipating it'll be later than that, but they got to be ready to roll if they actually say that. And, she could adopt it. Anyway, it'll be very interesting to see what Team Trump does on Monday, but particularly interesting and important to be there on the 28th when she sets the trial schedule. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.